worst case scenario happens, there's some accident that takes place with something that is not included in the waiver of liability because it is a risk. Hello there, and welcome to another exciting episode of the Conscious Counsel podcast with your host, Cory Sterling. That's me. As always, if you're listening to this podcast, the intention and the purpose is to give you the confidence and clarity to grow your health and wellness business properly. Now, as if you've been following the podcast, some weeks we have guests, some weeks we do solo episodes. The solo episodes focus much more on legal issues and legal things that come in my inbox. And with the guests, we're speaking with industry leaders who have insights on the health and wellness industry. And so I thought that it would make sense to have both types of episodes. And moving forward, we're going to alternate between having guests and solo episodes. When I do record a solo episode, I'm recording it because one of my clients is going through something that you should know about. And it's something that is really, really important that I want to share with you, that these things actually happen. And my clients go through these things and they really should be prevented, because in some ways it drives me crazy because I share the same information and I try to make it really, really simple and basic, but sometimes people just don't listen or don't know that they have to work with an industry-specific lawyer. And then they get into situations like this week's episode, which I'm going to share with you. So in this week's episode, I'm going to talk about a concept that I have discussed before, and I'm going to share a new story that involves a lawsuit for a lot of money. And the principle is that you need to have legal agreements that are specific to your business. You need to update your legal agreements to make sure that they reflect what you're doing in your business. The reason why this is so important is if you have not updated your agreements and you're offering something new or doing something different, and the agreements do not reflect that, it is like not being protected. It is like being in a car without a seatbelt. And I know that you're thinking, oh, do these details really matter? Does it actually make a difference? The answer is absolutely yes. And so I want to explain why. And then I'm going to share a story of something that I'm going through this week with one of my clients. And you're going to understand everything. And at the end of this episode, you're going to be in a way better position to stay legally protected and avoid lawsuits. When you sign a legal agreement, it outlines the scope of the relationship that you have with someone. What's covered, what's not covered, what's included, what's not included, how are you classifying a worker, what sort of injuries can arise from a particular problem, all those sorts of things. What I see happen with a lot of clients is two things. One is there'll be a new client, they'll send me their documents to review before they hire me, and they'll say, hey, I've been using these agreements for 2 years, and I'll look through the agreements, and then I'll say, oh, cool, well, I was on your website, and it says that you're doing these types of classes, but your agreements don't mention anything about that. And they'll be like, oh yeah, that was something that we recently added. And I'll be like, okay, cool. Well, just so you know, you're not protected in that particular case. If something happens around that particular issue, you won't be protected. Why? I'm going to explain how the situation works. If there's a problem and someone gets injured, or one of your workers is disgruntled and you have them as a contractor, but you treat them as an employee, if there's a problem, the question's always going to be, what does the last signed agreement say between the parties? And so if the last signed agreement that you have doesn't say anything about this new change or how you're operating or anything related to that, then you have a weaker legal position. And if you want, you can go back to the first episode I've recorded for the Conscious Counsel podcast, where I talk about what legal position is and why it's so important. And if you have a weaker legal position, you're not able to negotiate well or have something go from being a really, really big problem that keeps you up at night and that you're crying about versus something that you just forward an email to me and I can take care of for you. So what I want for all my clients is for them to have the strongest legal position possible. So the two alternatives are, one, you're using generic AI or templated agreements that aren't specific to your business, in which case, if there's a problem, you won't be protected. Or situation two is clients are using agreements that just simply haven't been updated. This is why we created the Conscious Counsel Plus membership, so that clients can always have their documents updated as part of the membership fee. Something changes, cool, let us know, and we'll update it for you to make sure that you're at best practices. And the answer is also, yes, the documents need to be re-signed every time that you update your agreements. So It's really, really important. Now, the situation and the story that I'm going through with my client now, and I'm just going to breathe because I don't know if you can tell, but I get worked up about this because I try so, so hard to help my clients stay safe, but they don't always listen. Client is a successful yoga studio in the state of Florida who has a studio and is crushing it and is awesome. And they started doing collaboration events in public spaces with another studio as well in this public space. And so the waiver of liability that they had did not mention anything about doing services, offering services in an outdoor space, and the risks of what can happen if you're operating services in an outdoor space. Secondly, with the venue that they put the event on with, there was no written agreement saying who would be responsible in the event that something happened, right? This is very basic. If you're operating something in a space that's not your studio, your agreements have to reflect that. And if you're using a public space or a third-party space, you should have a space rental agreement that says, okay, if something happens, you're going to be responsible and we're not. And otherwise, we don't agree to participate in this particular thing. Situation's very straightforward of what happened. Client runs the event. There's a signed waiver because the participant was a studio member, so we have a studio waiver signed. We do not have a waiver signed for the event itself and the particular risks of operating outdoors and things that can happen when you're operating outdoors, and there's no signed agreement with the venue. Unfortunately, worst case scenario happens. There's some accident that takes place with something that is not included in the waiver of liability because it is a risk that takes place from the environment of practicing in this outdoor venue. And so the client says a lot of things to me. And the first thing that this person did was sign up for a membership so that we could have unlimited consultations. And I say, okay, cool. You guys know what's the first thing I said? Send me a copy of the signed waiver. Send me the waiver. I say, okay, cool. This waiver is for your studio. Was there a waiver that you included or that you adapted to make sure that you were covered for any risks or damages that could take place when operating outside of the studio? The answer is no. So now, okay, we have a waiver to cover yoga poses or using yoga equipment or using straps or using blocks or slipping in a handstand or something like that, but we don't have anything about the actual risk that materialized and the damages that followed. My next question was, send me an agreement that you had with the venue. We didn't sign an agreement. Okay, now the client's freaking out. We get a letter from opposing counsel. The person who got injured hired a lawyer. And now my client's in the process of getting sued for a lot of money. And the legal position that my client has, unfortunately, is inferior because these things are true. The things are true is that the risk that materialized was not included in the waiver. In this case, it had something to do with practicing outdoors in another space. And there was no space rental agreement with the venue itself. And now, unfortunately, we're behind the 8 ball. And I'm explaining to my client, okay, we have an inferior legal position. These are the things we have to prepare. And now they've had to hire me for another scope of services, which is very expensive in addition to the whole process. And it's just like, it so easily could have been prevented. And that's what I want for all of you. So the point of this episode is that, do you need legal agreements for the different relationships you have? Yes. And sometimes I'm explaining to the clients and they think it's overkill. They're like, oh, if I'm doing this event at this space, do I really need to have a space rental agreement? And do I really need to update my waiver of liability? The answer is yes, because if something happens, it will be so expensive and so much not fun for you. You will be stressed. You will be crying. I don't want this for anyone. And it's easily preventable. This is just like, if we're professionals in the health and wellness industry, we do things properly. We have agreements for our different relationships. The agreements reflect the type of activities that we're operating. That's what I want for all of you. So in summary, in this episode, what I'm sharing with you is the importance of making sure your agreements reflect the actual services that you're offering, whether this relates to renting out a third-party space in order to run an event, and making sure that a waiver of liability captures all the different activities that you do in all of the different environments where you may do it. The story I told you is about a client of mine in the state of Florida who was running a yoga event in public. and there was an injury that happened from something in the space, in the outdoor space, that was not covered by the studio waiver, and there was no space rental agreement to say who would be responsible in what situation. And now we're in a sticky mess, and I don't want this for anyone. If you're interested about a Conscious Counsel Plus membership so that we can support you, so that we can update your documents, just go to consciouscounsel.ca. You'll see a tab for memberships. Click it, hop on a call with me. I love working with my clients. I love seeing everyone protected. And whatever you do, make sure you work with a lawyer who loves you. Stay safe.